What started as a routine courtroom hearing quickly turned into a shocking showdown between a defendant, his own attorney, and the judge. The judge tried warning him again and again, but he refused to listen. Moments later, the courtroom exploded into tension, accusations, and a decision that could change his life forever. Watch closely, because one wrong choice in this courtroom may have just cost him everything.
All right, what is happening with Collins?
Well, Your Honor, we've conferred, and he has.
So you have an attorney here.
Yes, ma'am.
She went to law school.
He did.
She has a license. And I can tell you that none of us who went to law school spent over $100,000 for law school and did not know what we were doing. So it's sort of like if you, I don't know why people sometimes think attorneys' jobs are not real for some reason. And I can say that because I've been a defense attorney and a prosecutor.
Oh.
And it is similar to if you go to see a doctor and you have a heart problem and you want heart surgery, you don't tell that doctor, hey, wait a minute, let me just tell you how I think this operation should go. You just let them do it. Once they tell you, this is why you need heart surgery, this is how we're going to do it. You don't tell that person, well, I really think you should use this type of scalpel, and I really think you should use this laser, and I really think this is the direction you should go. So you understand what I'm saying? If your attorney does not want you or recommend you speaking to me, there's probably a good reason for that. And I'm sure she may have told you that. Knowing that, if you still wish to speak to me, you may speak to me.
Man, I would.
Yes.
I would like to speak to you because I know that my attorney has gone to law school just like you have.
No.
And
No, just go.
I'm sorry. It's I'm very nervous.
Do not be nervous.
I'd rather fight for my life because even though my attorney went to law school, she has not had my discovery today. I've seen asked to see it, and
all right, let me stop you right there. Just 1 second. So with regards to discovery, your attorney has just told me that there are some new cases, right?
Yeah, but I have an indictment.
No. I know you may have the indictment, but this is what people don't understand. And let me explain the process to you a little bit. And this is me coming from prosecutor background and defense attorney background. Usually when cases are indicted, your attorney finds out the cases have been indicted. Maybe if the prosecutor has time, they will call them and they will say, hey, we're indicting Mr. Collins' case today. Normally that doesn't happen. What ends up happening is your cases get indicted, and then your defense attorney is aware it's been indicted because they get a message on the system that it's been indicted and they've been appointed. And then they have to make arrangements with the prosecutor to actually see the file. And then once they make arrangements with the prosecutor to see the file, then they can go see you. The state doesn't say, oh, here's the entire file, take our entire file over to the jail or take our entire file to the client. What ends up happening is they come to court and you'll be able to see the file if the state actually has their file. So that's how discovery works. I know a lot of people will see things on television.
No, I'm sorry. I just asked her. She said she didn't bring it today, so I was assuming that she had it and she didn't bring it. That's what she told me.
No. This is what ends up happening when she says not bringing your discovery. And correct me if I'm wrong, Ms. Thorne. What happens is they may have something uploaded on their system, but the state will normally have a file down here. And if the state does not have their file down here, she can't show you discovery. And if you ever have a chance to look at what they receive on the system, it is not the sheets of paper. They have to go in, download it, and get it. And then once they download it, maybe they can show it to you on their computer or something like that. But I will tell you, 9 times out of 10, defense attorneys don't walk around with their computers. So what's your next issue?
Honestly, ma'am, I've been up for 3 years. the day that you the day that you agreed on my deal that I testified on, I I did not know when you sentenced me to probation. You asked me if I had a child at the time, and I said no. Well, my child was conceived the night before. I have a 2.5-year-old daughter, and I I did. I got comfortable. I, I was walking. I was walking straight and narrow. I work at Barber Experts. I had a full time job. The contractor with CPS Energy and the tree climber, master trade, and I got comfortable. So
All right, so
I
let me stop you right
I
there.
want to plea on
Wait.
what's true.
Let me just do this. Let me stop you right there. See, this is probably why your attorney doesn't want you speaking. And let me just explain something to
I
you.
would like to go, ma'am. I would honestly at this point.
No.
I would
Time
like to
out.
pro se.
Stop. This is why your attorney probably doesn't want you speaking, because you're about to admit things. It sounds to me, maybe I'm wrong, maybe I'm making assumptions, but you're about to admit to things in the MTR, and you're about to say that this is true, this is true, this is true. And who knows? Maybe the state won't be able to prove those allegations. And your attorney does not want you saying that, because it sounds like to me you're trying to throw yourself on the mercy of the court, right? Because you're saying, I want to admit to what I did, and what I didn't do, I'm not going to admit to it because I didn't do it. Well, I would always tell my clients when they wanted to throw themselves on the mercy of the court, you got to put something in my hands. It just can't be, please don't sentence me. And so maybe your attorney needs time for that. But what I can tell you is you're not getting out of custody today.
Yeah.
Okay. So where are we on these new cases?
So one of the cases Ms. Thorne does not have discovery on because it is at large, but I can provide the discovery to her today. It's not alleged in the MTR, but it's point. It has been considered in when making an offer. I'll just say that for the quarter. Other than that, I've tendered an offer that resolves all of his MTRs or his pending case. The last I spoke with, because he doesn't seem to contemplate that, so my assumption is probably he speaks that for a contested.
All right. So, Mr. Collins. So, I don't want to know what the offer is, but the state has just informed me that they've tendered an offer to your counsel. And I'm sure your counsel has tendered that offer to you. And maybe you don't like that offer, but I don't want to know what the offer is. I'm not allowed to. And maybe you don't like that offer. That's fine. But if you want to contest it here, we'll go forth with a contested hearing. Or if you want to plead true, you can plead true. And I will make a decision on what to do about this motion to revoke. But that may change the state's offer if you all don't have an agreement. And usually on motions to revoke, I will follow the agreement that the state and the defense have worked out, unless there's a good reason for me not to, or if I think it should be something else. Do you understand?
Yes, ma'am.
All right. So now you know that your attorney doesn't have all discovery because there's a case that's at large, and I'm sure she'll explain to you what at large means. She doesn't have access to that yet. The state has said that they will be willing to give her the access to that and the information about that. So that's where we are in your case.
Yes, ma'am.
All right. Do you have any questions?
No, ma'am. I was still I was still like to proceed. I just don't I don't feel comfortable. I don't feel comfortable the way I saw her talking about me too. Yeah, I'd rather leave my life at this time in my own hands. If I can go pro se, if I can just leave it up to you, Miss Boyd.
Well, I mean, you can still plead true to whatever you want to plead true to and leave it up to me. And your attorney will argue whatever she wants to argue. The state will argue what they want to argue. And if you want to testify before me, you can.
I would rather I'd rather do that, man. I would rather.
Okay. All right. You want to discuss things with your client?
Your Honor, based on the things that you've said and I said earlier, I would like to ask for an oral motion to withdraw because I do not feel like we're able to communicate, and I don't think I can adequately represent him. He wishes to proceed pro se, and I need to withdraw, Your Honor. I think there's a conflict.
All right. Just have a seat and I'll take this up in a moment. All right, Miss Mr. Collins, you're requesting that Ms. Thorne withdraw from your case?
Yes. And I would like to proceed closer.
Listen to my question,
Yes, ma'am. Sorry. Yes, ma'am.
Ms. Thorne.
Yes, Your Honor, I wish to withdraw, Your Honor, based on, his comments to the court, his comments to me. I believe it's in the best interest for him to, have other counsel. And I do not believe that, I can absolutely represent him. I believe that there's a conflict and it's based on what he said on the record here in front of me.
All right. And State, do you have any objection to the defense's oral motion to withdraw?
No.
All right, that will be granted. Thank you, Ms. Thorne.
Thank you, Your Honor.
Have a great rest of your week. We're off the record. You can have a seat. Ms. Thorne,
Yes, Your Honor.
do you have any documents or anything from his case for the attorney who will be appointed?
No, Your Honor, I do not, other than the motions to revoke, I can,
No, that's fine. They'll get a copy to them then.
right. No, Your Honor, I do not.
All right, thank you.
Thank you, Judge.
This case proves that in court, every word matters, and sometimes the biggest mistake is thinking you know better than your own lawyer. If you enjoy real courtroom drama, shocking judge moments, and intense legal confrontations, make sure to subscribe, turn on notifications, and never miss the next unbelievable case. Because the next courtroom twist might be even crazier than this one.